Good afternoon or good morning, depending on what time you are watching this video. I am excited to be talking with you about legal rights and education law. My name is Shannon McMinimee. I am a resident of the Yakima Valley. I'm a lifelong resident of the Yakima Valley. I'm originally from Sunnyside, and I am an education and civil rights attorney with Cedar Law. We have offices in Yakima and Seattle, and we represent students, families, and employees in issues involving primarily school districts, colleges, and universities. And I'm here to talk with you a little bit today about rights associated with public education, particularly at the pre-K-12 level. So rights and things that are important to know as a parent or family member or friend of somebody who has a student in K-12 education. First and foremost, if you are one of those people, congratulations for still being upright during the time of pandemic when things are particularly challenging. And I want to really start by talking about the world of remote learning and what things you can be asking for as your child or your family member walks through remote learning. I'm going to start with students with disabilities. If you have a child who's a student with disabilities, whether that is a student who's on an individual education plan, IEP, because they're in special education, or they're a student who has a Section 504 plan because they're a student with a disability but are not in special education, you have a right to ask for a meeting to talk about how your child is going to be uniquely served during this time. So while all school districts in the Valley are for the most part serving students remotely at this time, that doesn't mean that the door is closed to making individual decisions for students with disabilities. So if you are a parent who's struggling with your child, who really needs in-person services in order to make academic gains, or if the services just aren't working remotely, or if your child is somebody who gets their own special paraeducator at school and they're just really struggling without that dedicated service, you have a right to ask for a meeting to talk about that and come up with an individual plan for your child that best suits their needs. It's not just taking what the school is offering for everybody. Your child's federal rights continue to be in play despite COVID. There's no COVID exception to that. I've seen a lot of teams act really flexibly during this time, which is really great because the IDEA is supposed to be about individual decision making to begin with. So if you are a family who has a student with a disability who's struggling right now, please ask for an IEP team meeting or a Section 504 team meeting and really ask school staff to engage with you on how to meet the individual needs of your child at this time. So what about if your child is an English language learner? You can ask for that as well. You can ask for specific plans in order to discuss how your child is going to be able to meaningfully access education. Remote learning and online learning is a challenge, but there are lots of ways to deliver instruction. And to be clear, the state has left the door open for in-person services to be provided to specific students who really need that service, those services in person, even before everybody else comes back to school. One of the questions we've been getting asked a lot about is discipline in this virtual world. What happens if your child gets essentially suspended from school by being kicked off of Zoom or Teams or whatever remote learning platform your school district is using? Just like if your student was in school at this point in time, you have a right to procedural safeguards and what's called due process associated with removing your child from school as a disciplinary measure. So if your child is getting removed from Zoom, you have the same rights to paperwork and notice as if they were getting a short-term suspension or being removed from school. So if something like that is happening, I encourage you to talk to your school principal or assistant principal and ask for the paperwork associated with a suspension so that you have the ability to challenge those decisions. I know it seems weird asking for paperwork to establish that your child was suspended from school, but it's only when you get that paperwork that you can go ahead and take advantage of the rights to challenge the discipline and potentially have that removed. Otherwise, your child just misses out on education and you don't have a recourse necessarily in front of you or a path to make up for that or to fix potentially a bad decision. So we're going to step back and talk about the world of education when we're not in the middle of a pandemic. What rights do students and families have in K-12 education? There's a bubble that exists around students in public education that says that they have many of the constitutional rights that we as adults all have in other settings. Though in some cases, they're tailored or limited a little bit for the special nature of the school setting. Here in Washington, we all have a constitutional right to a basic public education at the K-12 level. And so your child actually has a right to be in school and to receive educational services. If you find yourself in a circumstance where your child is being disciplined or removed from school, or even where you're getting called and asked to come pick up your child from school, because you have the right to access education, you also have the right to challenge decisions to remove your child from education. One of the things that we see happen a lot is informally removing a student from school without suspending a student. And then parents get told, just come pick them up. Don't worry, they're not getting suspended. It's not going on their record. And that intuitively sounds like potentially a good thing, but again, because you're not actually getting the paperwork associated with it, you're not getting the opportunity to challenge the discipline and have it removed from your child's record if you disagree with it, or if it was wrong, or if it was unnecessarily harsh. So that is a opportunity to absolutely go ahead. If you're ever asked to come pick your child up at school for disciplinary purposes, or if the school staff say your child's out of control, please go ahead and ask for them to treat it as a formal suspension and give you the notice and rights associated with that so you can go ahead and challenge those decisions. And those decisions go to hearing officers, and it is not uncommon for schools and families to find a way to work out a disciplinary issue short of going to a formal hearing when a parent has challenged an issue. And just like with anything in life, you have a right to say, I disagree with this decision. Tell me why you made this decision and tell me more about it, and potentially challenge that. And so that's one of the ways in which the law is set up to protect parents and students, is to give you that right to challenge disciplinary decisions made by school districts. How do you know if a decision is well supported, or if your child is being appropriately disciplined, or is this discipline potentially too harsh? Well, all school districts are supposed to post and have available their discipline policies and procedures, and what's called a student code of conduct or a student rights manual that set out the expectation for student behavior in schools, that identify the different types of things that might be subject to discipline, and the steps that the school district will take to impose discipline, with a real focus on what schools can do before removing a student from school. So those are the real things that you should look for. And if they're not posted on your child's school's website, or if you can't find it, you can always ask the school office for a copy of the discipline policies and procedures and the student code of conduct handbook, so that you can assess whether your child's discipline issue is being treated consistent with policy and procedure. One of the big areas of challenge for families in public school right now is dealing with bullying. Bullying can come in all different forms, both in-person bullying, online bullying, text message bullying, and it's a really hard thing to address, but it is something that students in Washington have very specific rights associated with. They have the ability, Washington has special laws related to what's called HIB, harassment, intimidation, and bullying. And those laws talk about not only the steps school districts must proactively take to keep students safe from these things at school, including annual training to staff and posting of information and the process that complaints get investigated by, but they also identify what happens when a student or family member, or what should happen when a student or family member raises to the school an issue of bullying. And there's an obligation on the school's part to conduct a fair and impartial and prompt investigation of all allegations of harassment, intimidation, and bullying. And there's very specific timelines associated with what the school districts are supposed to be doing, how quickly they're supposed to act, and how quickly they're supposed to get back to you as a parent to tell you what the outcome of the investigation is and what they're going to do in order to be able to move forward and keep your student safe at school. And so, again, that's one where if you're reporting a bullying issue, the school should be giving you a copy of the bullying policy and procedure. And if they don't, you absolutely have a right to ask for that and then to ask for them to follow that policy and procedure. One of the things that I talk a lot about is there are things that school districts can't discipline students for because they happen at home, in the community, and they don't come back and impact students at school. But it doesn't mean that they're necessarily things that the schools can ignore. And a lot of times that comes up with issues related to bullying. It might be something that's not happening at school, but it can still be addressed at school, even if the students involved aren't being subject to discipline. So there are lots of different ways in which bullying can be addressed, but what's not okay is for it to not be addressed at all. So if you're in a circumstance where you're dealing with your child being subject to harassment, intimidation, or bullying, that's another great one to go talk to your principal and assistant principal about and ask for the specific policies and procedures associated with harassment, intimidation, and bullying. And many school districts have handouts and posters and things that kind of take that policy and procedure and put it into plain English and in Spanish so that you can access it and really understand what the expectations are in a more clear way. So I mentioned Spanish because I think it's important for folks to understand school district obligations with respect to interpretation and translation services. We live in a very diverse community where folks speak different languages. Obviously, Spanish is very heavily spoken in the Yakima Valley. And as a parent, you have a right to important communications about your child in your native language, the language that you best understand. And if you're in a circumstance where your child is getting referred for special education, in special education, being subject to discipline, being subject to truancy issues, things like that, you have a right to access that information in Spanish. And so if it's not something that's being provided to you in Spanish, you absolutely have a right to ask for that. And let's talk a little bit about interpretation. You have a right to interpretation by an impartial person who has the skill set and training necessary to give you a quality interpretation. It shouldn't be the person that you're having a conflict or concern with. If, for example, you disagree with the decision of an assistant principal, you shouldn't have that person shouldn't be the interpreter present when you're talking to the principal about what you disagree with. And it's not your responsibility to bring somebody with you to interpret or translate for you. It's the district's responsibility to make that person available to you. I can't tell you how many times over the years that I've had clients where a student's sibling has been asked to interpret, or they bring in a staff member who speaks Spanish but may not necessarily be a good interpreter. And it can get really challenging, especially if you're dealing with complex issues or issues that involve special legal meaning, like special education or discipline, where it's important that the words get accurately translated and they be given their accurate meaning. So if you're going to have a meeting with a school and you need interpretation services in Spanish, you have a right to ask for that ahead of time and to get a quality interpreter. And so if you're consistently running up with a problem against that, that's definitely something to raise beyond your principal and to the school district itself if it's just not happening. And in most school districts, their website has an identification of who their non-discrimination officer is. In fact, they're all mandated to identify who that person is. And if you're consistently dealing with not getting things in your language or not getting proper interpretation services, it's that person who's in charge of non-discrimination who is your contact person for asking for proper interpretation services. So you're going to want to look for the non-discrimination page and then identify who is the compliance officer or equal opportunity officer or the discrimination officer and ask that person about making sure that you get communication in a way that you can understand, and whether that's in writing or having good interpretation at meetings. So let's talk about another area of law that is pretty much a hot topic right now, and that's Title IX. Title IX is a reference to federal law that talks about equitable services for students regardless of sex or gender. Traditionally, it's what we think about when you think about sports teams and making sure that if there's a boys' baseball team, there's also a girls' softball team. But it has broader meaning, and it really is intended to also protect students from discrimination at school based on their gender or sex, or from sexual harassment or sexual violence at school that may happen because of the student's gender or sex. And it's important to know that if something happens to your child at school that is a sexual assault, unwanted physical touching, sexual harassment, name calling that's based on sexual terms or gender terms, that's not just discipline. It may also be a Title IX issue. And there are times where it might also involve the police because it's a potential criminal act as well. But there are special obligations that school districts have to investigate those situations and to put in place interim steps to keep kids safe during an investigation. And every school district is required to have a Title IX officer to help explain to parents their school district obligations and student rights under Title IX. So if you're in a circumstance where your child is being singled out or treated differently because of their sex or gender, or if they're getting called names that are associated with sex or gender or sexual orientation, that's something that can be addressed not just as harassment, intimidation, and bullying, but also through Title IX. A big area that I get asked a lot of questions about is what do I do if the person who is harassing my child is a staff member? Who do I report it to? Well, the answer is generally, again, the principal or the assistant principal, but sometimes it may be a circumstance where you take the issue to them and they don't move it forward, or it doesn't feel like it's going anywhere. That's again where you can go to the non-discrimination officer or the Title IX officer, and it's the expectation that that person moves forward and identifies to you what the process is supposed to be. So I know that's a lot of jargon, and there's a lot of terms in education that are abbreviations, and there are a lot of different agencies and different things out there. And so I think it's also important to talk about what kind of resources might be out there for you as a parent if you're trying to navigate an issue and you want more information than just watching this Facebook Live or finding out information from the school district. Well, if you're somebody who has a child with disabilities, whether they are eligible for special education or Section 504, there's a great resource called Rights Law, WRIGHT. That is a website that has a lot of information about the laws associated with disability and special education in Washington, and that's a really good resource for parents. There are also a lot of websites. There's a lot of information on what's called the Office of the Superintendent of Public Instruction, big acronym, OSPI, that talks about rights associated with students. So there are some websites, and I'll link them in the comments when this video is done, that could be good resources for you to look for to get further information about the specific issue you and your family may be facing. Now, there are all kinds of different ways in which you can reach out for in-person support. If you are, oh, well, there you go. Quinn is graciously putting the links in there for me so I don't have to put them up while I'm talking. There are agencies who might be able to assist you in addition to just going online. And I also want to encourage you to look for Facebook groups of families who might be dealing with the same situation. There are a lot of Facebook groups out there for parents who are struggling with school issues, and you can talk with other parents and find support and resources. Here in Washington, there is an organization called Team Child that provides representation to students and families in really specific circumstances. They have an office here in Washington. The Northwest Justice Project at times handles school issues, and they have sometimes have a presence here with respect to school law issues. There are a lot of different groups out there, and I will put some more of those groups in the live, in the comments when the live is done to help find additional resources. But again, there's some agency websites, there's your school district's website, there are Facebook groups, so there's some resources out there that can help you steer towards the right answer for yourself. And then there's also, big challenging issues where you might want to reach out to an attorney to see if it's something they can help you with. So I see that somebody might have some questions. I'm going to see if there's any questions. If not, I will turn to talking about another topic that is a big issue, and that's student speech in schools. So I'm going to pause for a second to see if there are any questions. Okay. I'll keep looking at the comments to see if any questions pop up. An area where there's a lot of time for there to be conflict between families and students and schools is around what students say at school. And I always like to remind students that they have a First Amendment right in public education. They have the right to speak freely, but it is not the same as adults in other circumstances. So what can students get disciplined for saying or expressing in school settings? Well, you're not allowed as a student to threaten others. Any true threat of violence is not going to be protected speech. So that's one of those areas that if a child engages in a threat of violence at school, the school is within their power to discipline students for that. And when you think about it, schools also have that same responsibility to keep students safe, right? We send kids to school every day and we expect that they come back every day and that they are safe and that nothing bad happens to them while they're in school. So just as schools have an obligation to keep kids safe when they're under their care, they can take action against students who make threatening comments to help keep kids safe. That one's pretty straightforward. Where do things get a little bit more challenging? Well, deciding if something a student has said is going to potentially disrupt an educational environment. Is it going to cause a riot? Is it going to cause students to walk out of class? That's an area where schools can also take action to limit student speech in school if it's going to be disruptive of the educational environment. Another area where school districts can regulate student speech is associated with vulgarity, profanity, and obscenity. So there are a lot of things you can say in schools, but you can't say things that are obscene, profane, or vulgar. Pretty straightforward, and that's again because students are obligated to be in school, and so schools can go ahead and restrict what is said in schools in order to make sure that other students aren't being exposed to things that are obscene, profane, uncivil, that sort of thing. Another area where school districts can take action is to address drug speech. So if the actual case comes from Alaska and it was during the run-up to the Winter Olympics, where in Salt Lake City, and the torch came through a town in Alaska, and the students from the local school were allowed to go outside and watch the torch relay come through town, and one of the students had a banner that said "Bong hits for Jesus," and that student got suspended from school. The U.S. Supreme Court has decided that that kind of speech is one that schools can take action to regulate. Another area where school districts can take action to regulate speech is when it might be perceived as being speech of the school. So Schools can, for example, change words in a play if they're putting on a play and the play would otherwise have swear words, or they can exercise some discretion over the content of school newspapers and things like that, because people could reasonably believe that what is in a school newspaper or what is in a school play represents the views of the school. So that's an area, so it's just one of those areas where it's interesting and students have a right to express themselves, but there are limits on that. And as we come up on an election, this is also a time where we get a lot of calls as school law attorneys for kids who get in trouble for political speech. Now, political speech, unless it's going to be disruptive, is the most protected kind of speech, and you're not supposed to be able to discipline a student for supporting one political candidate or another, or expressing their support for one political candidate or another, unless it crosses the line to being dangerous or unsafe or a threat of violence. So that's just one that always tends to pop up around elections, is what are the limits on what students can say about politics? Well, they can express their political views, they can wear shirts that represent their viewpoint, so long as they otherwise comply with a school dress code. You can wear hats that express your political viewpoint, unless, of course, there's a school dress code that says no hats at all, and that's okay because it applies to everybody the same. But it's one of those things where you sometimes come into challenges associated with unpopular opinions or unpopular viewpoints getting people in trouble, because there's either a concern that it might cause a problem, or people don't like the opinion that's different from them. And that's where schools can really get into trouble, is if they try and discipline somebody for expressing a political belief that isn't necessarily popular or isn't the general belief that everybody else has. But that is one where students have the right to express their viewpoint and their opinion, again, so long as they do it in a manner that's not going to disrupt the educational environment and is not going to cause big issues at the school. And you'd be surprised at how many things that, how many different ways in which kids can engage in political speech in a way that's still safe and that's still respectful and still provides for civic engagement. So I'm really proud of a lot of our, particularly our high schoolers, that they're able to engage in the sharing of viewpoints without it turning into probably they handle it in some ways better than adults. But it's just important to keep in mind that students are allowed to express their political views and controversial views, so long as they do so in a manner that isn't disruptive. So I have been talking for about half an hour. I want to check in and see if anybody has any questions. And I'll let Quinn, who's our moderator, let me know if there's any specific area that she'd like me to touch on that I haven't talked about yet. So I'm going to pause for a second. All right. I'm going to talk a little bit about some of the challenges associated with dealing with a school district when you and your child's other parent may not be married or may have had a contentious divorce, and how do you navigate that dealing with the school district? First and foremost, it's really important that you provide your school with a copy of your current parenting plan, that court order that explains who has decision-making authority for what, at the beginning of the year, and then every time that may change, or if there's a new order issued, to give that to your school so that they know the basic parameters of who's allowed to make decisions in your family and who's allowed to have access to information and to the school. In Washington, most child custody orders provide for joint educational decision-making authority, or name a specific one of the parents who has decision-making authority. That's really different than who may have residential custody, because custody here in Washington is really about identifying who gets to take a tax break. It's not necessarily any special privilege with respect to decision-making or making one parent more important than the other with respect to deciding who gets to make decisions. So it's important to know that even if you're the only parent your kids live with, their other parent may have educational decision-making authority that's equal to yours. And if you don't have a parenting plan, it's de facto that they have equal educational decision-making authority. So that, just keep that in mind. So what the school is going to look for is to know who is the parent who has educational decision-making authority under your parenting plan, and they're going to look to that person to make decisions. If the decision-making is joint and you and the child's other parent disagree, it can be a little bit of a challenge to navigate that, especially on issues like what school your child's going to go to and is your child going to participate in a special program or not. And if the decision making is joint, either parent has the ability to consent to participating in services or to accessing different schools. So it's important to keep that in mind because equal does mean equal, and it can get messy. And usually what happens if there's not agreement between you and the other parent is you have to use whatever dispute resolution mechanism is in your parenting plan to resolve the issue. And the school's going to stand back and wait for that issue to be resolved rather than trying to decide which of the two parents they're going to listen to. But it's really important that if you have equal decision-making authority and the other parent is controlling all the decision-making authority, to remind the school that you have decision-making authority too. And generally, both parents are going to have equal access to educational information unless the court has specifically identified that one parent is not going to be authorized to access information. And usually when that happens, a specific reason is given for why that parent is going to be blocked from accessing information. If that's not the case, both parents have the right to equal information. And that means it's okay to ask the school to send things to both houses to make sure that both parents get communication. So it's not put on you to have to send things to the other parent or to go get things from the other parent. And it's perfectly okay to ask for both things to be sent to both households that the child may live in. Now, how do you know what school your child is supposed to attend if you are in a joint custody situation? Or what happens if you're raising your niece or nephew or grandchild and maybe you don't have formal custody? Well, where your child lives decides where they have a right to go to school. And that doesn't matter. It doesn't matter if you have legal custody or a court order. It really is where does the child live and where do they put their head on a pillow at least 4 nights of the week. So if you live in one school district and your child's other parent lives in a different school district, your child has a right to attend in the school district where they spend the majority of their time. And if it's truly an equal situation where you're doing like 1 week here, 1 week there, they have a right to go to both school districts. So that's one of those circumstances which can get a little bit tricky as you're trying to decide these things, and know that you have the chance to pursue whichever school district works best for your child if you're truly 50-50. And then every place else, it really is where is your child putting their head on a pillow 4 nights a week, even if that where they're staying isn't some place that has legal custody of them or a court order. So that's just an interesting and important thing to know about where it is your child has a right to go to school, because the right belongs to the child. And so where the child is really dictates what's going on. And there's a special law called the McKinneyVento Homeless Assistance Act that's really designed to help kids who might be part of families that are homeless or might be in a circumstance where they don't have any adults with them, or they're bouncing among family members, that gives them specific rights to stay in a particular school or to get transportation to a particular school. So that's a special set of rules that apply to families who are experiencing homelessness or housing insecurity. And that applies even if you're not, even if you're like staying with a family member, or it isn't something that only applies if you're in a homeless shelter or if you're not or if you're living, in an alternative place. It also applies to people who are temporarily staying with other family members or staying with friends. So if you find yourself in that situation where you need support to keep your kids in the school they were at or to get transportation, the McKinney-Vento Homeless Assistance Act is there to help support families who are experiencing challenges associated with housing, and also to support kids who may not be with their parents, unaccompanied minors, folks who are, or who are living with family members other than their parents, but doing so informally. All right, I'm going to check in again to see if there are any questions. going to spend a couple of minutes wrapping up on the topic of what can you expect with respect to sending your kids to school when that happens again, because I know we're all looking forward to the day in which kids are back in school, and the expectations that are placed on school districts to keep your child safe when they're at school. We often get asked, when does that obligation start? Well, it's for the period of time where your child is in the control and custody of the school district instead of your control or custody. So really, it starts from when they step on that school bus, or if they're going to an official school bus stop, until they come back home at the end of the day. And it applies to school-sponsored events and activities like sporting events and plays and that sort of thing. Children have schools have a special legal relationship to kids because kids are mandated to attend school in Washington if you are over the age of 7. So you have to go. So in turn, school districts have an obligation to keep kids safe from reasonably foreseeable harm. And that's to make sure that school districts are proactive in addressing things all the way from, are your buses safe, to, is this a safe activity to engage in with students. And so you have a right to expect that the school district is taking reasonable steps to keep your child safe when they are at school. And what is reasonable may depend on the circumstances. If you're in a situation where there's something specific going on with your child that puts them at a higher risk, you can always ask for what's called a safety plan meeting or a safety and support plan meeting to make sure that the steps are put into place to keep your child safe at school. That can be from an outside source, like if you're involved in a contentious family issue where there's somebody who doesn't have custody, who's threatening to take a child, to concerns among students in schools, to just general circumstances where you need the school district to be working with you to keep your child safe in school. So there are lots of things that school districts can do. Everything from making sure your child is not in any classes with a specific other child, to setting up a person for your child to check and connect with every day so that they have a person they know they can go to if they're having concerns or conflicts or things like that arise. So that's one of the other resources that are available to you as a parent, is if you're dealing with a safety concern, you can always ask for your school assistant principal or principal to hold a safety planning meeting to talk about concerns you may have and how to keep your child safe at school. Now, one of the other things we get asked a lot about is student records and how do you keep information about your student private and safe. There's a law called the Family Educational Rights Privacy Act, FERPA, and every year you get a notice, or you should be getting a notice from your school district telling you about what the school district does with respect to keeping student records safe and how you can access student records. It's important to look through that FERPA paperwork and understand that you have a right to access any records the school district has about your child, and you can ask to see those. And if they're right now where going to school and looking at records isn't exactly easy, you can ask for them to send you copies at no cost to you. And those records are generally not supposed to be shared without your consent, with some specific limitations. And so you have a right to ensure that your child's educational records are something you can access, and that they're generally kept private, except for if people have a legitimate reason under the law to know that information. And so that's another one of those areas where school districts are supposed to send you a notice. It's usually 3 pages long and super complicated. But if you have a specific question about wanting to get copies of records, or if there's a concern that you have related to somebody else accessing records for your student, that's one where you, again, can talk to your school administrator and make sure that you understand what the school district is doing to keep those records safe and to make those records available to you, and also to ask for more information if you need specific help with a specific problem. And that's something that you can continue to do as a parent even after your child turns 18, so long as you're still claiming them as a dependent for tax purposes. So you can, after your child turns 18, they have the right to make decisions as an adult unless you've gotten guardianship of them because they're limited capacity or special education, or there's some specific reason for that. They get to do things like excuse their own absences or try and excuse their own absences, but you don't lose the right to access educational information just because they turn 18, so long as you're still claiming them as a dependent for tax purposes. And of course, your child can always continue to allow you to access information even if you're not claiming them for tax purposes, if they want to involve you in educational decision making. Okay, as we wrap up the hour, I want to take a moment again to see if there are any questions, or if there's any particular topic that we haven't touched on today that folks would like to know more information about. So I'm going to pause for a minute or so to see if there are any questions. All right, well, I'm gonna wrap up then by restating what I said at the beginning, which is during times of COVID, it's okay to ask for a meeting, to ask for specific special help for your child if whatever it is the school is doing generally isn't working for your child. Particularly if your child is a student with a disability under Section 504 or has an IEP, it's perfectly okay to ask for a team meeting to talk about what your child specifically needs. Same for students who are English language learners and access through remote learning only might be really challenging for them. Also, if your child is hearing impaired or visually impaired and it's just not working, there are specific expectations around school districts making sure that your child can access educational content, even if it's not the same as what's happening for everyone else. So please go ahead and ask for those meetings if you're encountering challenges in how your child specifically is accessing education at this time. I'm going to put some resources in the comment section for folks to be able to look at later to help them answer questions about special education, harassment, intimidation, and bullying, school discipline, and also the Family Educational Rights Privacy Act. So if you need some resources moving forward, you have some places to look. And I thank you all for taking the time to watch this video and learn a little bit more about education law and what rights and expectations families should have in K-12 education. So thank you all and have a good day, and look forward to more links in the comments.